These PowerPoint slides are taken directly from our Florida state-specific supplement. So we do a full-day course on use of force law. We call it our advanced class. It's 6-7 hours in length. We teach it live once or twice a year. But of course, we also make it available as a DVD, as online stream format. But it covers all 50 states. So it's kind of generic in that sense. Where there are variances in the states, we do point those out. But the full day course is not state specific, so we supplement that with state specific supplements. We have separate supplements for each of the 50 states. This is the one we have for Florida. Florida's, and this is section 9 of that course, the defense of property course. So I'm not going to go through all these slides here, but we do distinguish defense of property between least defensible property, which is just personal property. Under Florida law, only non-deadly force to defend personal property at best, and highly defensible property, like your home. And you may be privileged to use deadly force in defense of highly defensible property. So let's take a look. Here's just the defense of property statute. You can use force or threaten to use force except deadly force to stop simple trespass, criminal interference with property, personal property in your possession. This is just defense of simple personal property, non-deadly force only. But it has to be your property in your possession or that of a member of the family or property you have a duty to protect, like you're a loss prevention officer in a store, for example. But you're only justified in using deadly force in the context of defense of property if you're stopping a forcible felony. Well, a forcible felony is a threat of force against a person. So we're really now talking about a defense of persons scenario. Here are forcible felonies: treason, murder, manslaughter, sexual battery, carjacking, home invasion, robbery. You can see these are all actually acts of violence against a person. Then we have, so that was statute 776.08. Sorry, that's the forcible felony definition. Defense of just personal property, 776.031. Defense of your home is a different statute because different legal doctrines apply. 776.013. Home protection. Use of deadly force. Defense of your dwelling. What does dwelling mean? Dwelling means a building or conveyance of any kind, including any attached porch. That means this homeowner, if the woman she shot Owens was on her porch, it's treated as if the woman were inside her home for purposes of the definition of dwelling. Residence, vehicle, those aren't particularly relevant here. Don't add much here. Justifiable use of deadly force, yet another statute, 782.02. The use of deadly force is justifiable when a person is resisting any attempt to murder such person or to commit any felony upon him or her or upon or in any dwelling house. Is aggravated battery a threat of aggravated battery, attempted aggravated battery, grave bodily harm caused in the course of a battery? Is that a felony? Yes, of course. Would a 58-year-old woman be exceptionally vulnerable to injury, to great bodily harm in a manner that a 25-year-old man would not be? Sure. Here's the relevant jury instruction. It says the same thing as the statute, so I won't bother reading it. And then we have the defense of highly defensible property, special legal provision. This is common in many states. If you're defending yourself in your home against an unlawful enforceable intruder, a legal presumption is created that you had a reasonable fear of imminent death or great bodily harm. Folks, that gives you 3 of the 5 elements of self-defense right there. It's legally presumed that you had a reasonableness, fear of imminent, that's imminence, peril of death or great bodily harm. That's proportionality. That's 3 of the 5 elements of self-defense right there. You also don't have avoidance here because Florida stands your ground, but also because you're in your castle, you'd be relieved of avoidance anyway, even if Florida was not a stand your ground state under the castle doctrine. So that's 4 of the 5 elements needed to justify the use of deadly defensive force. The only one left is innocence. And innocence is rather baked into the cake. If you're in your home dealing with someone attempting to forcibly and unlawfully enter your home. So let's take a look at this provision in more detail. 776.013, home protection. A person is legally presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself when using or threatening to use defensive force that is intended or likely to cause death or grave bodily harm to another if the conditions of the statute are met. So what are the conditions of the statute? The person against whom the defensive force was used was in the process of unlawfully and forcefully entering a dwelling. Is that what was happening here? Remember, the state would have to disprove beyond any reasonable doubt that Owens, the woman shot, was attempting, they have to disprove that she was attempting to unlawfully and forcibly enter the homeowner's home here. Remember the banging on the doors, the banging on the walls? Could there be even just a reasonable doubt that Owens was attempting to unlawfully and forcibly enter the home? And also required the person who uses or threatens defensive force had reason to believe that an unlawful and forcible entry was occurring or had occurred. Well, the homeowner would be observing that here. Then there are exclusions to this presumption, but I don't believe any of them would be triggered here. One of them is that the person against whom the force is used had a right to be in the dwelling. That's not the case. That it involves a removal of a child from the dwelling. That exclusion doesn't apply. That the homeowner here was engaged in some other criminal activity. There's no evidence of that. Or that the person against whom the force was used was a law enforcement officer. Nope, that's not the case here. By the way, there's another legal presumption, a second legal presumption, atop the one we just described that gave the elements of self-defense to the defender. There's a legal presumption about the person entering unlawfully and forcibly. The same statute, different paragraph. A person who unlawfully and by force enters or attempts to enter a person's dwelling is presumed to be doing so with the intent to commit an unlawful act involving force or violence. This is the presumption that applies to Owens. If she was unlawfully and by force attempting to enter this woman's homeowner's dwelling, Owens is legally presumed to be doing so with the intent to commit an unlawful act involving force or violence. In other words, a forcible felony, an independent justification other than defense of home to use deadly force in self-defense. And there's the jury instructions on making the same argument. By the way, the last time I checked, so most of these legal presumptions of a reasonable fear that I've been talking about, in most states, they're rebuttable. In other words, the state may have other evidence that's contrary to the presumption. Maybe the homeowner had stated to a friend that she intended to orchestrate a killing, for example. But the appellate courts of Florida have said, no, if the jury finds that the conditions of the presumption have been met, it's unrebuttable. It's an irrebuttable presumption. Cannot be rebutted by the state, by the prosecution. Here's that decision. The creation of 776-013, the home defense statute we were just looking at, eliminated the burden of proving that the defender had a reasonable belief that deadly force was necessary by providing a conclusive presumption of that reasonable fear of imminent deadly force harm. State v. Heckman, Florida, Court of Appeals, 2007.